Yeah. I'm not gonna lie, rather had gonna
Well, we've got some lawsuits that probably aren't going to be dismissed as quickly as this. We've got
That is for sure.
JOOLA filed their suit against USAP, what, 6 months ago or something? And then just recently, we had the announcement that USAP is now, is this the correct term, countersuing
Claiming,
JOOLA,
yes. Yes.
counterclaiming JOOLA. So can you take us through really briefly the first JOOLA claim, and then what is USAP doing by counterclaiming JOOLA?
Yeah, this is the super interesting one to me of the different ones that are out there. I mean, this is right up my alley of stuff that I would have done, either representing YOLA or representing USAP, a corporate lawsuit. So to me, it's really interesting. So the basic dispute is YOLA comes out with the Gen 3 paddle. Pursuant to typical practice, they create prototypes. They send the prototypes to USAP for approval. They are, and these are undisputed facts agreed to by both YOLA and USAP. And I'll be careful to state what is undisputed and what is
Sure.
disputed, because that really matters. So undisputed, they send in prototype paddles. Undisputed that the prototype paddles are approved. As you know, the Gen 3 creates an uproar in the pickleball community. The paddle's too hot, the paddle's too good, this paddle should be banned. Subsequent to the public uproar, YOLA, it's a little unclear exactly whether it's YOLA saying that the prototypes have differences to the as marketed paddles, whether USAP discovers it, whether people independently discover it. But in any event, it does come out that the as marketed paddles have differences from the prototype paddles. That's not disputed either. USAP then delists the paddle. They do not follow the procedures outlined by USAP under their own published equipment standards. That again is undisputed. The equipment standards specifically state that to delist a paddle, you must post the notice on their website and wait 18 months to delist it. They do
Even if
not.
there's some sort of error from the paddle manufacturer?
Well, that again gets into the disputed side. So I'm being careful to say the undisputed part first. It is
Sure, okay.
undisputed that there is that equipment standard. The dispute is whether there's a legal dispute over whether that standard applies or not, for exactly the reason you're saying. But it's undisputed that there is the delisting standard with 18 months and that they do not follow it. USAP has reasons for what they did. Whether those are legitimate legal reasons is what the dispute is about. But in any event, YOLA then sues USAP for delisting the paddle and failing to follow the 18-month rule.
Mhm.
USAP first responded by asking the court to dismiss the lawsuit outright. And as I posted on Facebook, I wouldn't say it's inappropriate that they did that, but that motion that they filed had virtually no chance of success. That type of early motion dismiss is where you say to the court, under no factual circumstance can my opponent win. Even if every single thing they say in the complaint is true, they still won't win, which
Mhm.
is an almost impossible motion to win. And in my 30 years, I probably saw that type of motion filed. Well, saw it filed hundreds of times. I maybe saw it succeed once. It's usually filed as a delay tactic, or people will accuse lawyers of trying to run up their billable hours by doing it, just trying to make extra money. But in any event, it was no great prediction, but as I correctly predicted, it was dismissed by the court. The motion was denied, and then the court required USAP to file a substantive response to YOLA's complaint. That substantive response was both a denial of YOLA's allegations and also the addition of the counterclaim, suing back USAP, claiming that YOLA had committed fraud and that
Wow.
USAP was entitled to damages for that fraud, and asking for.
What do the damages relate to? Just the damages to USAP's reputation? Like, I mean, this is where people seem to throw around enormous numbers, right? YOLA's throwing around 200 million. What is USAP claiming these damages are for, and for how much?
Well, two different things on that is when you hear somebody say, they're suing for 200 million or some other number. Almost invariably, that number is meaningless and just done for media purposes.
Sure.
When you file a lawsuit, you do not, except in certain cases, sue for a certain amount of money. You only do that when it's like a contract.
Sure.
Um, I promise to sell you a car for $50,000. I deliver the car. You fail to pay me the $50,000. I sue you for $50,000. I may
Right.
have additional claims for interest or attorney's fees or something, but basically I'm suing you for the $50,000 under the contract. When it's this type of claim, a claim for what we call tort damages, there's no specified amount. It'll be up to if it goes that far, up to a jury one day to say what the damages are based upon the evidence. So when JOOLA says we're suing for 200 million, it's an entirely made up number that has no legal force and effect. It doesn't limit the claim. It doesn't mean if they win, they'll get 200 million. They might get more, they might get less. It's really done as a media thing. So I can say I'm after you for all this money. Same thing with USAP claiming back. Now, USAP does have some statutory claims that talk about regurgitation of fraudulently made profits and things like that that can have a some certain ultimately, but it will all depend on proof down the road. But certainly, it's fair to say that there are millions and potentially tens of millions of dollars or even more at issue.
Gotcha. Well, it seems to me like all of this is going to hurt USAP regardless of the outcome more than it's going to hurt Yola. I think Yola seems to know what they're doing, and I think that they can withstand a multi-million dollar lawsuit even if they're found to be fraudulent. And I think that this feels like more of a, at least from my the seat that I sit in, this feels like a more of a shit talking match with some legal repercussions, of course, but like it feels like the main deal was obviously we're pissed and about the whole process and we want to throw shit at each other on this. Who do you think does this, who does this hurt more?
Um, well, I think they're both at risk to me. And as I first posted when the lawsuit started, or even before there was talk of a formal lawsuit, but we sort of saw it coming. I said this is the perfect case to settle early. That if I was the lawyer for Yola or I was the lawyer for USAP, I would be advising immediate settlement talks. And once the lawsuit was filed, if I was USAP's lawyer, I would have again asked the court to delay the proceedings. Let us talk. Let's see if we can work it out. Don't be filing motions to dismiss. That motion to dismiss probably cost USAP $20,000 or something in legal fees and all the attendant processes that are going on at the same time. You're spending a lot of money, as I mentioned, you're moving apart. And the lawyers should be giving a budget to their client. Again, on both sides. This is not directed at one versus the other. This is both sides. You could be talking about $1 million in attorney's fees, experts, or even more than that, depending on how much is out there and how many documents there are and how much time you have to go through reviewing it. So as each side incurs $1 million, look at how far apart they are, as opposed to starting now when you haven't incurred all that. The parties who really are benefiting from a lawsuit like this that goes on are the lawyers and the
Yeah.
experts. They're getting paid win or lose.
Mm-hmm.
So a good lawyer is going to look at their client and say, you know, you've got two choices. You can try to settle this case, which is some sort of 50-50 case. Anybody who looks at this thing and says it's 80-20 or 20-80 is is not giving good advice to their client. They should be telling their client, you're in a 50-50 battle. You might be
Mm-hmm.
60-40, you might be 40-60. Let me look at the documents. If there's some smoking gun, maybe that moves it. But at this point, the two lawyers only know at best the smoking guns that hurt them. If I'm
Sure.
USAP's lawyer, the only email I know about is my own clients that may hurt me. If I'm Yola's lawyer, the only internal documents I know about are mine that may hurt me. So I have no reason to say, hey, the other guy's got this document that's going to make our case. So I've got to be saying 50-50, 40-60, 60-40. You want to incur $1 million on a coin flip? That to me is not, in my opinion, that's not good business. That's not good lawyering. Now, to your point, who's more at risk? I don't know the exact finances of JOOLA, but you and I know they're selling a hell of a lot of paddles. I think they got money coming in. I do know USAP's finances because it's public record and they have to file their documentation. I haven't looked at the latest one, but traditionally have had about $1 million to $1.5 million in the bank. That's gone on attorney's fees.
Mm-hmm.
I don't understand what their motivation is to fight. If I was their lawyer, I would have said right up front, let's just go to JOOLA and just do the 18-month rule.
Mm-hmm.
That's an
Interesting.
easy, simple settlement. It doesn't hurt USAP at all. There's no downside to them. They save $1 million in fees and costs. So what that JOOLA gets to market the paddle another 18 months?
Yeah,
You know, we can make arguments. Yeah, that's not good for the game to have this too powerful paddle or something. Sure. But it is backstopped at 18 months. Why that didn't happen, I don't know.
Yeah.